Welcome to literary and jury charge practice. Let's start out with some literary material. This is called Captioners Say, I Love My Job. Ready? Here we go. The JCR reached out to 5 captioners to get their take on the benefits, challenges, and future of captioning in a roundtable discussion by email. Despite the high-stress nature of the job, these captioners found it to be the perfect fit for them. Tell us a little about the kind of work you do. Anna Marie Jones. CART is my passion. I initially started out in 2006 working on site at colleges and universities in New Jersey and Philadelphia, commuting 1.5 to 2 hours each way. I did not mind the commute at all because I love what I do. Then one day, the second day of the spring semester of 2014, we had an ice storm here. I slipped on the ice, broke my right ankle, and was unable to drive or go on site for 2 months. I was heartbroken. I felt like I had deserted my student, who I had been mainly working with. Then, with the help of an awesome colleague, I contacted a few remote captioning agencies and was very fortunate to have enough remote work to get through this semester. Thank you to Jen and Shannon. Also, thank you to Pat Graves, FAPR, RDR, CRR, CRC, Corinne Merrick, RDR, CRR, CRC, and everyone else who sent work my way during that time. Now that I've discovered the world of remote CART and broadcast captioning, I freelance and work remotely with approximately 7 to 10 CART and captioning agencies. I also travel to on-site work in New Jersey, Pennsylvania, New York, and Washington, D.C. as needed. Amanda Lundberg. After moving to Pennsylvania from Iowa, I started 100% captioning and then moved to CART captioning after 2 years. I do mostly CART now, but I have a few captioning jobs here and there to keep my skills up in that area and use my ability to prep sports really fast. I love to challenge myself every day, so I rarely say no to an assignment that I can cover unless I feel I don't have the time to dedicate to properly prepping for it. I do mostly remote, but I do on-site as well. I go where I am needed, so I have traveled to Pittsburgh, Philadelphia, DC, San Francisco, Boston, which I joke is my second home since I am there several times a year, and many other places. It is great to be able to mix it up, and going on site can be a great way to get motivated. Often, if I'm in a place where attendees can see what I'm doing, they will come up on breaks and ask questions, and I'll let them write on my backup. The best way to grow our profession is to let people know that we are people doing this and not some computer somewhere. Brooke Nunn. When I started out, I did a lot of on-site work in Washington, D.C. However, now most days I work from home doing remote CART and broadcast captioning. Each day is different. I caption a lot of business meetings and webinars, but I also frequently caption college classes, newscasts, TV shows, and special events such as graduations. Also, I travel to about 7 to 10 conferences per year in various cities across the U.S. to provide on-site captioning. Tammy Milkowitz. I do both broadcast and stadium captioning as well as CART captioning. I like to do both for 2 reasons. 1, doing the broadcast captioning helps me keep my speed up. 2, I need to shake it up a bit. With my personality, I get bored easily, so I need both to keep me entertained. My CART captioning is mainly remote, consisting of educational CART, business calls, and webinars. I also go on site sometimes. I am not on site frequently, but I do enjoy it. It's a rush like no other to see your captions on a big screen in a room filled with hundreds of people. I have a set schedule of broadcast captioning on a weekly basis, and once a month I have weekend duty. During the college school year, I fill my days in with classes as best I can, and then after the college class schedule is set, that is, after students have dropped, added, and changed classes, then I try to fill in the gaps that are open in my day. Sometimes that's a last-minute pickup, and sometimes it's something that I add to my schedule a week prior. Josh Foley. I do a mix of broadcast and remote CART. DC gave me a lot of on-site experience with a wide range of subjects, from government meetings to psych evals, different types of conferences, doctor visits, etc. Once I had to do car with scrubs and latex gloves on. I do miss working on site with other writers during conferences. I hope to be able to do some in the future when I visit the States. I have my skeleton schedule, which consists of about 8 hours of news a week, and from there I add on more broadcast and remote CART. I love academic CART. I also do a lot of government work, webinars, conference calls, and some stadium captioning. The only thing I don't do is sports. I tried, but it's just not my thing. Take a little break there from that article. Get back to that. And now let's try some jury charge practice. Ready? Here we go. The word youth should be given its ordinary everyday meaning. Youth refers to a period when one is young and has not yet reached adulthood. A juvenile is a youth. To find that the government has satisfied its burden of proving beyond a reasonable doubt that Mr. Sarr committed the offenses on a victim who was particularly vulnerable due to youth, you must all agree that the victim was vulnerable due to his youth, and that there was a connection between the victim's vulnerability and the offense committed upon him. A connection does not necessarily mean that the defendant targeted the victim because of the vulnerability. It means that once targeted, the victim was more susceptible to death because of the vulnerability. Again, your finding as to this statutory aggravating factor must be indicated in the appropriate place in Section 3 of the verdict form. Finally, let me reiterate that if with respect to any capital count you do not all find the government has proven beyond a reasonable doubt at least one of the several statutory aggravating factors, your deliberation as to that count are concluded. Let me turn now to non-statutory aggravating factors. If you have unanimously found that the government has proven beyond a reasonable doubt that the defendant was 18 years of age or older at the time of the particular offense, has proved the existence of as to that particular count of at least one gateway or threshold intent factor, and at least one statutory aggravating factor alleged by the government, you must then consider whether the government has proven the existence of any alleged non-statutory aggravating factors with regard to that same count. You must all agree, and separately as to each count, that the government has proved beyond a reasonable doubt the existence of any of the alleged non-statutory aggravating factors before you may consider that non-statutory aggravating factor in your deliberations. Again, any such finding must be based on Mr. Sarr's action and intent. The law permits you to consider and discuss only the 6 non-statutory aggravating factors specifically claimed by the government and listed below. You're not free to consider any other facts in aggravation that you may think of on your own. The non-statutory aggravating factors alleged by the government with regard to the capital counts are as follows. First, in conjunction with committing acts of violence and terrorism, Mr. Sarr made statements suggesting that others would be justified in committing additional acts of violence and terrorism against the United States. The government alleges this factor in connection with all of the capital counts. Second, the government alleges that Mr. Sarr caused injury, harm, and loss to Chris Camp and her family and friends in counts 1, 2, 3, 6, 7, 8, 12, and 13. To Mark Sanders and his family and friends, counts 1, 4, 5, 6, 9, 10, 14, and 15. To Liz Liu and her family and friends, counts 1, 4, 5, 6, 9, 10, 14, and 15. And to Officer Sean Collins and his family and friends, counts 1, 6, 16, 17, and 18. The third non-statutory aggravating factor alleged is that Mr. Sarr targeted the Boston Marathon, an iconic event that draws large crowds of men, women, and children to its final stretch, making it especially susceptible to the act and effects of terrorism. The government alleges this factor in connection with counts 1 through 10 and counts 12 through 15 only. The government alleges that Mr. Sarr demonstrated a lack of remorse. The government alleges this factor in connection with all of the capital counts. The government alleges that Mr. Saar murdered Officer Sean Collins, a law enforcement officer who was engaged in the performance of his official duties at the time of his death. The government alleges this factor in connection with counts 1, 6, 16, 17, and 18 only. Finally, the government alleges that Mr. Saar participated in additional uncharged crimes of violence, including assault with a dangerous weapon, assault with intent to maim, mayhem, and attempted murder on April 15 in 2013 in Boston, Massachusetts. That's for counts 1 through 10 and 12 through 15, and on or about April 19, 2013 in Watertown, Massachusetts. That relates to counts 1 through 10 and 12 through 18. That is all the capital counts. These non-statutory aggravating factors are set forth in the verdict slip, and they are generally self-explanatory and do not require further instruction. I do want to provide further instructions, however, regarding two of the non-statutory aggravating factors. The first non-statutory aggravating factor I would like to address is the government's allegation that Mr. Saar has, quote, demonstrated a lack of remorse. In determining whether the government has proven this fact beyond a reasonable doubt, you may not consider the fact that the defendant has not testified or made any statement here in court. I remind you the defendant has a constitutional right not to testify or speak, both at the first phase of the trial and at his sentencing hearing. Again, there may be many valid reasons why a defendant would exercise his constitutional right not to testify. You must therefore not draw any conclusion against him as to any issue from his failure to testify at this stage of the trial. The second non-statutory factor on which I need to provide some additional information is the allegation that Mr. Saar participated in uncharged crimes of violence either directly or as an aider and abettor, as I previously defined that term. To find the defendant committed, and you'll recall that I listed the ones that, and you'll see it in the verdict form, lists the other uncharged crimes the government claims. So to find the defendant committed an assault with a dangerous weapon, the government would be required to prove that the defendant forcibly assaulted a person with a deadly or dangerous weapon, and secondly, the assault was done voluntarily and intentionally. To find the defendant, the then committed an assault with the intent to maim, you would be required to unanimously and beyond a reasonable doubt find that the defendant had forcibly assaulted a person, that the assault was done voluntarily and intentionally, and third, that the defendant intended to cause a permanent disability. An assault is any intentional and voluntary attempt or threat to do injury to the person of another, when coupled with the apparent present ability to do so sufficient to put the person against whom the attempt is made in fear of immediate bodily harm. Forcibly means by the use of force. Physical force is sufficient and actual physical contact is not required. You may also find that a person who in fact has the present ability to inflict bodily harm upon another and who threatens or intends to inflict bodily harm upon such person acts forcibly. In such a case, the threat must be a present one. A deadly and dangerous weapon is an object used in a manner likely to endanger life or inflict serious bodily harm. A weapon intended to cause death or danger but fails to do so because of a defective component is nevertheless a deadly or dangerous weapon. To find the defendant committed the uncharged crime of mayhem, you must find beyond a reasonable doubt and unanimously that the defendant maliciously disabled or disfigured someone permanently or deprived someone else of a limb, organ, or part of his or her body. Second, that when the defendant acted, he intended to permanently disable or disfigure the other person or deprive the person of a limb, organ, or part of his or her body. To act maliciously means to act with the intent or with the willful to do that or with willful disregard of the likelihood that damage or injury would result. To find the defendant committed the uncharged crime of attempted murder, you must all find and beyond a reasonable doubt that the defendant intended to commit the crime of murder, and second, that the defendant engaged in a purposeful act that under the circumstances, as he believed them to be, amounted to be a substantial step toward the commission of that crime. A substantial step is an act in furtherance of the criminal scheme. It must be something more than mere preparation, but less than the last act necessary before the crime is completed. The substantial step may itself prove the intent to commit the crime, but only if it demonstrates such an intent. Murder is defined as the unlawful killing of a human being with malice aforethought. Malice aforethought means an intent at the time of the killing willfully to take the life of a human being, or an intent willfully to act in a callous and wanton disregard of the consequences of human life. But malice aforethought does not necessarily imply any ill will, spite, or hatred towards the individual killed. In determining whether a victim was unlawfully killed with malice aforethought, you should consider all the evidence, considering the facts and circumstances preceding, surrounding, and following the killing, which tend to shed light upon the question of intent. Again, your findings regarding these non-statutory aggravating factors must be separate as to each count and unanimous. You must also unanimously agree beyond a reasonable doubt that the non-statutory aggravating factor alleged by the government is in fact aggravating. As I mentioned at the beginning, an aggravating factor is a fact or circumstance that would tend to support the imposition of the death penalty. All right, we'll take a break from jury charge and get back to some literary practice. This is an article called Happy Feet. Ready? Here we go. When you travel, it's important to care for your feet. There are so many things going on in your feet. Certified massage therapist Marilyn Keir says the feet and ankles contain 1/4 of the human body's bones, plus 33 joints and more than 100 muscles, tendons, and ligaments. No wonder walking a lot can cause pain and fatigue. A foot massage can improve circulation, stimulate your muscles, ease pain, and boost your endorphins, and you can do it yourself. Start with clean feet and scented oil or cream. Lavender is relaxing, while rosemary and peppermint are good pick-me-ups. Sit in a chair with one foot on the floor and the other leg bent so that the shin rests across the opposite thigh. Warm the oil or cream in your hands and rub it on your foot. Take note of any tight or tender spots. Keir says, with your fingers, make small circles across the foot's width, pausing at those spots. Use alternating thumbs to stroke from side to side across your foot. Then use your knuckles to make circles in the arch, increasing pressure as you near your heel. Move to the toes, using your index fingers to work up and down the web between each toe. Then gently work around each toe's joints. Finish by flexing and pointing the toes and circling the ankle to lubricate joints. Use your own sense of what feels good in terms of pressure, Keir says. This isn't a case of no pain, no gain. By spending just 10 minutes on a rub down, you can start the next day off on the right foot. All right, we have a few minutes left, so let's try a little more jury charge practice. Ready? Here we go. In the event that you all find beyond a reasonable doubt that a particular alleged non-statutory aggravating factor applies to all the relevant capital counts for which you have found the defendant 18 years or older, and at least one gateway factor and at least one statutory aggravating factor, then you are to indicate that finding on the appropriate line in Section 4 of the verdict form. And you'll see that again, that is presented as the first option. In the event that you all find a particular non-statutory aggravating factor applies to some but not all of the relevant counts, you're to indicate that finding on the appropriate line in Section 4, and also to identify on the line provided by count number the particular counts to which you find the non-statutory aggravating factor applies. If you do not all find that a non-statutory aggravating factor has been proven beyond a reasonable doubt with regard to any of the relevant capital crimes, you should indicate that in Section 4 of the form. Now, unlike the rules relating to the gateway factors or the statutory aggravating factors, you're not required to find a non-statutory aggravating factor with regard to a particular count before you may consider the death penalty as a possible sentence for that count. The law requires only that before you may consider an alleged non-statutory aggravating factor as to any particular capital count, you must first all agree that the government has proven beyond a reasonable doubt the existence of that factor as to that count. After you've completed your findings regarding the existence or non-existence of non-statutory aggravating factors, you should proceed to Section 5 of the verdict form to consider whether any mitigating factors exist. Again, remember, unless you're unanimous that the existence of a particular statutory or non-statutory factor has been proven by the government beyond a reasonable doubt, you may not give that factor any consideration beyond in your deliberations. That is, as to any statutory or non-statutory factor you do not find to be proved, you may not consider that in your deliberations. All right, we will stop there. That will conclude our literary and jury charge practice.